Good morning, ladies and gentlemen. I'm Judge Tammy Long Hayward. This is the State Court of Clayton County. This is the calendar call for November 4th of 2024. These are cases where you have opted to go to trial, either a jury trial and you will get information today about your trial. Also, I'll be expecting to hear any updates regarding your case. If you're represented by an attorney, your attorney will speak on your behalf. If you're on the calendar, please make sure that you have both your first and last names on the calendar, not nicknames or names of phones like Samsung or iPhone, but your first and last name on the calendar, because that helps us keep track of who's here so that you don't get a bench warrant when you're actually here on the calendar. All right, I'm going to call the calendar for courtroom 304. All right. So I'm going to call the calendar for November 4th, 2024. This is the 10 a.m. calendar call for Clayton County State Court, Judge Tammy Long Hayward. First name on the calendar is Lazarus Marquise Black. Jordan Van Mater is the attorney.
And Your Honor, attorney Van Mater did file a conflict on October the 30th. I'm not sure if his client is on, but he did file a conflict.
All right, Miss. Do we know when the conflict ends?
1 second, Your Honor. Let me go to the. It appears that it's just for today based on the conflict letter. Today and tomorrow.
All right.
Looks like today and tomorrow.
All right, Mr. Black, we'll move your case to the next calendar call, sir. Please get in touch with your attorney.
Okay.
Thank you. All right, Nadia Harris Manning.
Good morning, Your Honor. Ms. Manning is on the Zoom call. I just asked for a breakout room to speak with her at the end of the calendar.
All right. Zalandria Anita Henry. Zalandria Anita Henry. Oh, Mr. Van Mater. Oh, shoot. I think I just sent your client away. If you want to give him a call, he can log back in.
Yeah, so yeah, I had a Superior Court conflict with Judge Amaro. I just got into my office. I'll go on. I'll close my video and try to get him.
Okay, when you can both come back on once you get him.
Thank you.
All right, thank you. All right, Zalandria Anita Henry. Last call for Zalandria Anita Henry.
It will move for a bench warrant, Your Honor.
Bench warrant will be granted.
Thank you.
Yule C. Johnson.
Thank you, Your Honor. Mr. Johnson is present on the Zoom call. Like for an opportunity to speak with Mr. Johnson, have Mr. Lynch will give him a call, and then we'll make an announcement after.
All right, Mr. Johnson, while you're speaking with your attorney, please make sure that your device is muted so that we don't overhear anything that would be privileged. All right, Jaleel Jones.
Your Honor, Mr. Jones is present on the Zoom call. Mr. Jones, can you contact me regarding the status of your driver's license appointments?
Yeah, I actually did set a driver's license appointment, but it's not till mid-December.
Okay, Your Honor, the basis of his charge is no license. We just announced ready at this time.
The state is also ready, Your Honor.
Okay.
Anticipate having a license to resolve this matter.
Mr. Jones, how old are you?
I'm 27.
Mr. Jones, how have you gotten through life without a driver's license?
A lot of circumstances where I guess I didn't need it. I kind of learned how to drive late after high school, and then I moved to California where I wasn't really required to have a license the way I was living out there. So, yeah, it just kind of escaped me as far as time moving on.
All righty. Okay, well, they've both announced ready, which means that you will probably pop up on the trial calendar for a jury trial. So please keep in touch with your attorney and be ready on the trial date, okay?
Okay, thank you.
All right. Shartavius Laney, Ms. Benz.
Good morning, Your Honor. I've spoken with the state about it. I mean, we could be ready. I think Ms. Hagler and I can probably resolve it short of a trial. I kind of came into the case late, so I thought today was just a calendar call. I didn't realize we were getting trial dates, but if we could be ready.
The state is
Okay.
also ready, Your Honor.
All right. So this is speeding, fleeing from police, improper lane change, and no license. So if y'all work it out, fine. If not, it's a 2021 case, so it probably will pop up sooner rather than later. Okay.
Okay, no problem.
All right. So we'll see y'all on the calendar on the trial date.
Okay, well, I'm sorry, Ms. Hagler, go ahead.
I was just telling the judge, thank you. That's all.
Oh, okay. Well, that's all we have. May we be excused, Your Honor?
Yes, ma'am.
Thank you.
All right, Tyrone Lamar Morrow, and I don't see an attorney for Mr. Morrow. Mr. Morrow? Oh, is it Lister and Holt? Oh, yeah, I see he has two cases. So I see Lister and Holt on one. I can appoint on the other if you want it.
Yes, Your Honor, please. I'll prepare that appointment order and have it to your office later today. We've spoken to Mr. Morrow on the obstruction case. So at this time, we wanted to resolve both of them. So we'd announced ready on the current case for the obstruction and just asked for the second case to be continued so that we could get discovery on that matter.
Okay.
And the state is also ready on the obstruction case, Your Honor, as well as the striking fixed object case. We're ready on both cases.
Yeah, they need discovery, I guess, on the striking fixed object case because they're getting appointed today.
Yes, ma'am, we'll provide that to them.
All right. I don't know how these older cases are just popping up after some of the newer cases, but we'll figure it out. Glenda Leslie Norman, that case is closed. Anyone here on Glenda Leslie Norman? That case is closed. You're free to go at this time. Mr. Van Meter, were you able to reach your client?
Yes, Judge. He said he would log back in.
Oh, there he is. All right, Mr. Black, your attorney was able to clear his conflict. Mr. Van Meter, do you have an announcement for Mr. Black?
Yes, Judge. We filed a special demurrer to the accusation in this case. My understanding is that's calendared for today. If so, we're ready to proceed on that. It's just some legal arguments. Shouldn't take more than 5 minutes or so.
All right. So let me finish the call of the calendar and then we'll come back and hear your motion, your demurrer. Okay.
Thank you.
Vincent Turnbull.
Good morning, Your Honor. Mike Hawkins for Mr. Turnbull.
Hi, Mr. Hawkins. How are you?
I'm doing well. How have you been?
I'm good. Mr. Hawkins, I know I owe you a motion, an order on a motion to suppress. I think I'm working on that. I'll get it out to you. It was during
That was just our announcement. We're just waiting on
not on this case. I think it was on a previous case. But yeah, I'll get that out to you.
Okay.
I was in the middle of a change of staff attorneys and things were a little chaotic for me.
Oh, okay. Oh, you're making that on another case.
Yes.
I'm sorry. And that
That's
Mr.
okay.
Turnbull is on our Zoom, and we are requesting if you would help schedule a pretrial motion for this case.
All right. What is it, like a motion to suppress, or is it something simpler?
It's a motion to suppress.
The Albert motion?
If I can look, Judge, and forgive me, I'm literally in the jury room in the Rockdale
That's
County
okay.
State Court right now, kind of
I understand this
multitasking.
allows y'all to work out of office. That's fine.
Yes, Your Honor. I believe, and I'm just going to pull it up real quick if I could.
Mhm.
I believe we have filed a Daubert motion in the case, Your Honor. I'm just going to look right now for Mr. Turnbull. So we have a number of Daubert motions, Your Honor, and then we have other ones involving statements, chemical tests, and field sobriety tests.
Okay.
So I guess what I would say is, and Judge, we've worked on these together before. I have reviewed the videos. It's been a few months. If there's any of these motions that I've reviewed, and I'll review my notes prior to that we can withdraw, we're certainly going to withdraw anything that we don't need to hear evidence on. But I think there are a number of motions that we would like to hear evidence on.
Okay. Ms. Val, can we put this? I don't want to hear this pre-trial because I think it'll be so extensive that it'll probably take the better part of a couple of hours. So
We could put it on December 9th, Judge. December 9th motion calendar.
okay, December 9th. I'm sorry.
Yes, December 9th.
Okay. Thank you. I was Mr. Hawkins, December 9th is that motions calendar. So we'll hear the Daubert motions then.
Have you provided a copy to the state?
Judge,
sir?
just looking at my,
Do we have a copy
yeah,
of your
these were
motion?
served a long time ago.
Okay.
Yeah, they
Yeah.
were served on you a long time ago. I'm just looking at my schedule, Your Honor.
Yes, sir.
I also have motions scheduled on it may be an older case. It's Marcus Smith. It's before Judge Knights in Henry County at 9 a.m. that morning.
Okay.
And that is an out-of-state client that the judge has set these motions on for me to bring Mr. Smith in. So I think that'll take the morning. Is this a morning or an afternoon motions calendar you have, Your Honor?
Usually our motions calendars are afternoon calendars. When we send the notice, if it's a conflict with Judge Nice, just let us know.
Yeah, just didn't want to have a client come all the way down here from out of state. But I know Mr. Turnbull.
Mr. Turnbull is out of state?
Mr. Turnbull, I believe, is local. The case that's specially set in front of Judge Knights is an out-of-state client.
No, what I'm saying to you is Judge Knights I know about. So when we send our notice, it's not an afternoon calendar and it conflicts, just let us know you have a conflict.
Yes, Your Honor. I believe Mr. Turnbull is on the Zoom, and I believe he is available locally. So just if that's what we were clarifying.
Mr. Turnbull, I mean, we can still do it on video too, if that is helpful. But as my understanding, the date of our motions calendar, your attorney may have a conflict, not definitely, but may. So if he has a conflict, he'll let us know once he gets back and can check his calendar when we send the notice, because ours is usually an afternoon calendar. But if he's unable to do it, then we'll switch it to the next motions calendar after that. Okay.
Okay, Your Honor, I'm presently working on disaster restoration in Tennessee.
You can appear from wherever you are, Mr. Turnbull.
Okay, that's fine.
Yeah, no, I get it. Yeah, so you can appear from wherever you are.
And Judge, while I'm here, if I may, who will be the assistant solicitor handling that? If they don't have a copy of my motions, I'm happy to forward a copy.
Ms. Hagler, is that you or Ms. Bing?
Most likely to be me.
Ms. Hagler.
We work together though, me and Ms. Bean, but me for right now.
Okay. All right.
Yeah.
If you don't have a copy of our motions, just please let me know, and I can arrange to have those sent to you. But they were served over a year ago. So.
Okay, and the number on the calendar, is that the best number for you, sir? In case I need to call you.
I apologize. I don't have the calendar. You know what number
I have
it is?
770-685-6400.
That's perfect. Yes, ma'am.
Okay. Thank you.
All right, Mr. Hawkins, you and Mr. Turnbull, we will see you on the 9th. If not, then we'll see you on the next calendar after that. Okay?
Thank you, Judge. Nice to see you.
Nice to see you too, sir.
Yeah.
All right, so we have Mr. Taylor, do you and Mr. Lynch have an announcement? What I want to do is put you all in a breakout room and then address the matter with Mr. Van Meter's client.
An announcement on,
No, I was asking if you all had any announcements. I do know that you want to speak to a couple of clients, Mr. Johnson and who else? I know Harris Manning is in the courtroom, you said, right?
no, she's on the call, Your Honor.
Okay, so Harris Manning, Johnson, Morrow. Did you still need to speak with Morrow?
He's on the call. No, Your Honor, not at this time.
Okay, all right. So I'm gonna put you in a breakout room with Ms. Harris Manning. Yes,
If you will put my computer in a breakout room with Ms. Manning and
yes.
courtroom computer available for Mr. Lynch.
All right. All right, Ms. Harris Manning, you and Mr. Taylor will be in breakout room number 2. I'm sorry, and I'll send the notice now. All right, Mr. Lynch, did you need to speak with someone on video?
Judge, I'm actually hoping to speak to Ms. Hagler prior to that. However, I know she's about to have to address a
Yeah,
special, so I
can
can
we?
hang off, and then after that's done, if she has a moment to speak to me, they'll just.
Okay, yeah, let's
What's
do
the
the
client's
demurrer
name
first.
again, Judge? What's the client's name again?
For the demurrer or for Mr. Lynch?
For Mr. Lynch.
I was gonna speak to you specifically about Mr. Johnson, Yule
Oh,
Johnson.
okay.
And
Johnson,
then
okay.
also follow up with you about Ms. Harris Manning as well.
Johnson and Harris Manning, okay.
Thank you.
Mhm.
All right, Mr. Van Meter, Mr. Black.
Yes, good morning, Judge.
Good morning. Ms. Hagler, this is yours, correct?
Yes.
All right, this is case 2024 CR 02438 for Lazarius Marquise Black for reckless driving, count 1, too fast for conditions, count 2. Mr. Jordan Van Meter is here on behalf of Mr. Black and has an argument for a demurrer in this case. The state is represented by Ms. Jameen Hagler, Assistant Solicitor General, and we're prepared to go forward at this time.
Thank you, Your Honor. It's my motion. So I will give a sort of a background, but ultimately this is an evidentiary proceeding and the state has the burden of proof on the legal issue.
Yes, sir.
Judge, in this case, my client, these are essentially traffic offenses, but he was accused in count 1 of committing an act of reckless driving. In count 2 was accused of committing the offense of too fast for conditions. In the amended accusation, the language of the accusations merely recites the statutory language and does not state with any specificity as to what conduct he actually did that is violative of these statutes. So, for example, count 1 reads that the solicitor for Clayton County charges my client with the offense of reckless driving, or that the accused on the 10th day of January in 2024 in Clayton County, Georgia, did unlawfully drive a motor vehicle in a reckless disregard for the safety and persons and property. Similarly, in count 2, the accusation accuses Mr. Black with the offense of too fast for conditions, or that on the 10th day of January 2024 in Clayton County, he drove a vehicle at a speed greater than reasonable and prudent under the conditions and without having regard for the actual potential hazards that existing when operating motor vehicle upon a public roadway. These are basically copy paste of the statutory language. There is no other averments in the allegations to give Mr. Black or myself any type of notice as to what conduct he's supposed to prepare his defense against, which is important because the discovery produced in the case only presents a citation. There's no police narratives. There's nothing to explain why he was pulled over, what the officer saw, and how exactly he is he was to have committed these offenses. And so the law permits us within 10 days of arraignment to plead a special demurrer, to challenge the form of the indictment, the accusation, and essentially make the argument that he should not be required to proceed to trial on this particular accusation because the form of it is not perfect. It doesn't adequately place him on notice as to what conduct he's supposed to defend against. And so in that procedural posture, the state now has the evidentiary burden of coming into court with evidence. So not just argument, but with actual witness testimony, documentary evidence, or otherwise, to explain to the court that it's not capable of making this accusation more specific. If they can't do that or they don't do that, then the remedy is for the court to quash the accusation. Now the state can reaccuse it if they want to, but it's a procedural mechanism that we're here on today. So that's sort of my opening background statement, and I'll leave it to the state to produce any evidence that they have.
All right, Ms. Hagler.
Thank you, Your Honor. Your Honor, the state will ask that you deny defense motion. As defense did state, the language on the amended accusation, again, is taken from the statute. And because it has been taken directly from the statute, the state will argue that defense counsel does have sufficient notice as to what his client is being charged with. Additionally, the citations that were provided to defense counsel is even additional information that has been provided to defense counsel to add, I guess, any additional information or content to the accusation. So because, again, we did take the content straight from the statute, we would argue that it is sufficient notice, and also the defense was provided a copy of the citations to add additional content or context to the accusation as well. And so for those reasons, Your Honor, we do ask that the state that you deny defense's motion for a special demurrer on these two charges.
If I can close on my motion, Judge.
You may.
Judge, it appears that the state has not brought forth any evidence. They have not called the officer to testify as to what happened in this case, or to otherwise explain why the accusing language cannot be more specified. There is Court of Appeals and Georgia Supreme Court case law that says that that mere argument alone in the face of a special demurrer is not sufficient to withstand or to meet the evidentiary requirement. There has to be some actual evidence produced to demonstrate to the court satisfactorily that the state has done all it can do to fairly place my client on notice as to what he's to defend against. I will just point out that the state is basically saying that citing the statute is enough, and that if you provide the citation itself in discovery along with the statute, that somehow is sufficient to withstand a demurrer, but that's not the case. The Georgia Supreme Court stated in the case of D'Auria versus the state, that's cited at 270 Georgia Supreme Court 500 from 1999, it's cited in my written pleadings. It said that although recitation of a statute may in certain cases be a sufficient, though not desirable, method of apprising the defendant of the charges against him, recitations of the portion of the statute is not sufficient if, reading the accusation together with the statute, the defendant is unable to determine which of his acts are alleged to be criminal in nature. And that's the point, Judge. This is a bit sort of unusual. As it happens, normally in a case like this, I get the citation, but I also get a police narrative that explains, that the officer was running patrol on Terra Boulevard or something, and he noticed the driver, or just whatever it was about the driver that made him pull him over. Something that we can look at it, and I can go over with my client and say, okay, this is what the officer is going to say when he testifies. This is what they're claiming happened. This is the factual predicate for the too fast for conditions and the reckless driving, etc. We don't have that. And while I'm
Mr.
here,
Van Mater,
yes.
let me ask you a question. I'm sorry. Does the accusation for too fast for conditions list what the adverse condition was?
No, it doesn't. And I was getting to that. And that's the court points out something that I think raises an additional reason why this demurrer should be granted, because there's nothing to differentiate between whether these two crimes. We don't know if the too fast for conditions is based on the same factual predicate as the reckless driving, or whether they're two separate courses of conduct. So I can't advise my client on merger. I can't advise my client on whether this is a 24-month risk or a 12-month risk. There's just nothing. Normally in an accusation, we see the citation of the statute and then a comma by driving 85 miles an hour in a 45, something like that. Something like that, as simple as that is, would place us on notice that, okay, the reckless driving is based on driving at a crazy speed, or the same thing with the too fast for conditions. There usually is some type of language where we can say, okay, this is what they're accusing him of, and this specific act of conduct is how they're saying he did it. That's what he's entitled to from a due process perspective, because it's not fair procedurally to have us go to trial and have no idea what the accusation is about, and then us prepare our defenses as best as we can, and then have the evidence, have the state move and shift and jockey their evidence in real time around our defenses. Procedurally, under the due process clause, we are entitled to more notice than has been given in the state, by the state. So I'm happy to answer any of the court's questions if you have any, but that's the essence of it, Judge. Pre-trial, the standard is whether the accusation is imperfect in form and substance. If it were after he was convicted and we were appealing it at that point, it'd be a harmless error standard. But prior to trial, the standard is whether the accusing document is perfect in form, which he's entitled to. It is certainly not, and I'd ask that the accusation be quashed.
Anything else from the state, Ms. Hagler?
Just briefly, Your Honor, regarding the count 2 for too fast for conditions, the accusation does list that the defendant was speeding greater than reasonable. So that is, I guess, the premise or the basis for too fast for conditions. And again, both acts were criminal in nature. The defendant did receive citations for those acts, which thus led to the accusations being accused in our office. And again, for those reasons, we do ask the court to deny defense's motion. Thank you.
All right. So yeah, there's been case law on this. If you just state the statute, and there are several ways to commit whatever the offense is that's stated in the statute, then the defendant is not given notice sufficient to allow them to prepare for trial or to make a confident decision about whether they should take a plea, whether they should go to trial. So in reckless driving can be several things. It can be merging into somebody. It can be going faster than necessary for whatever the situation is. It can be weaving in and out of lanes. For too fast for conditions, if the conditions aren't stated, or if it doesn't state why at that time, because the person can drive the speed limit and still be too fast for conditions. And if it doesn't state what conditions were present, the conditions precedent for the offense, then the defendant is left without knowing how to defend against the charges. And so for those reasons, the court is going to grant the motion, the special demurrer as to reckless driving and as to too fast for conditions, to the extent that neither of them is sufficient to apprise the defendant of the actual conditions or offenses that they should defend against. All right.
Thank you, Judge. Does the court need me to prepare an order to that effect?
Yes, please. That would be good.
And where do I send it, please?
Ms. Kiara Powell, Kiara.Powell, and Clayton County GA.gov.
Thank you, Judge. The signing of the order will effectively quash the accusation,
Yes.
and will that also remove it from the trial calendar?
Yes.
All right. And if the state sees fit to recuse, we will receive that in due course. But thank you, Judge. I'll submit that order.
All right. Thank you, sir. All right. I think Mr. Lynch wanted to talk to Ms. Hagler. I can put y'all in a breakout room. Mr. Black, Mr. Van Mater, you're free to go at this time. Jones has announced ready. Jones is ready for trial, and you're free to go at this time if you have not already been excused. Laney has announced ready, free to go at this time. I don't want to, tomorrow, I know that you were going to speak to your attorney about the case that they've just been appointed on. So ready on the obstruction, but just remain for the appointed case. Turnbull will be on the December 9th motions calendar. And we're waiting on, I guess, Johnson. So Mr. Lynch was going to speak with Ms. Hagler about the Johnson case and then speak with Mr. Johnson. All right. I'll put
And also
Mr.
Harris Manning to, I think, Attorney Lynch wanted me to speak with me.
Yeah, Mr. Taylor's talking to her right now. So
We can do it in the same way.
so Mr. Lynch, I'll put you and Ms. Hagler in breakout, and I'll put Ms. Bing into breakout room number 1.
Okay, thank you.
All righty. All right. All right, ladies and gentlemen, we'll be back.
Well, I guess I should just go call Mr. Johnson.
All right, I guess Mr. Lynch is preparing his announcement and we'll be back in a moment. Did you need a breakout room with Mr.? No. Okay.
Judge, can I actually request a breakout room with Mr. Morrow very shortly? Or, I mean,
Sure, you need it now or you want to go call Mr. Johnson first?
let me just talk to Mr. Morrow very briefly, and then
Sure.
I will speak to Mr. Johnson. I think we should be about ready to make all the announcements at that point.
All right, Mr. Morrow, I'll put you in the breakout room with the courtroom. Let me see. Did I put you in the right one? Probably not. 1 second. Nope. Hold on. 1, 2, 3.
Okay.
All right, so Mr. Morrow and the courtroom are in breakout room number 3.
Claro, licencia. No has podido sacar una. No.
Attorney Taylor, I'm going to send you a chat directly, but it's for Attorney Lynch. Since you're logged in, I'm gonna send you a chat directly for Attorney Lynch, please. Thank you.
Room, I'll tell him to take a look at it when
I can't play.
Okay.
Miss this fucking money though right now. Go ahead and play out. Fuck it.
Mr. Morrow, are you cussing? Are we ready? Mr. Morrow seems to be getting a little agitated. I think I heard cuss words.
I doubt that, Your Honor.
Yeah, it must be me getting old, hearing things.
Ms. Hagler, I'm going to send you a quick message about Mr. Johnson.
And there's a chat message from Ms. Hagel on my computer.
All right, we need to keep it moving because I got the 11 o'clock ready.
Your Honor, in the matter
Yes.
of Ms. Harris Manning, we're standing on our ready at this time.
All right, Harris Manning is a ready announcement. We'll see you on trial day.
Ms.
Yes,
Harris
ma'am.
Manning, I will be in contact with you. However, you're free to go today.
Thank you. Right. And Morrow?
Judge, I believe we were going to resolve the obstruction charge. Is that correct, Mr. Morrow?
Yes, correct.
All right. Yeah, I believe we'll be pleading no contest to obstruction and accepting the state's recommendation.
All right, Mr. Morrow, let me see you so we can get this done. All right, pull it down a little bit so I can see you. All right. Raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes, ma'am.
All right, you can put your hand down. So, Mr. Morrow, you're before the court on 2021 CR 07022, Tyrone Lamar Morrow. You're represented by the law firm of Lister, Holt, and Dennis. I'm sorry, wrong case number, 2023 CR 01367. So that's 2023 CR 01367. Mr. Morrow, Tyrone Lamar Morrow, you're before the court for obstruction of an officer. You're entering a plea of nolo. By doing so, sir, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, sir?
Mhm.
All right. Factual basis and recommendation, please.
Yes, Your Honor. On or about January 28th of 2021, pursuant to the probable cause affidavit that was completed by Officer Ronald Foley, the defendant knowingly and willingly obstructed Officer Foley by flight after seeing the defendant disregard a traffic control device at Flint River Road and Taylor Road, Clayton County, Georgia. The defendant drove off at a high rate of speed, striking a mailbox and Officer Foley's marked patrol vehicle. Officer Foley followed the defendant with lights and sirens activated to where the defendant stopped and exited the vehicle. At that time, the defendant was stopped and forced to the ground before being arrested and detained. Your Honor, at this time, the state's recommendation is a fine of $300.
All right. Anything on behalf of your client, Mr. Lynch?
No, Your Honor, he does have a slight difference of opinion as to how the stop went down. However, he is asking the court to accept a no contest plea and accept the state's recommendation at this time, and we would ask the court to do that.
All right. Sir, will he need more than 60 days to pay?
Mr. Moore, I believe you can get that paid in 60 days, right? If you need additional time, you're going to have to go on probation to pay that.
Okay.
So can you get it done within 60 days? Can you pay the $300 fine within 60 days, Mr. Morrow?
Yes.
Thank you, sir.
All right, so Mr. Morrow, I'm going to accept your plea of nolo. I'll sentence you to pay a fine in the amount of $300. It'll be $444 with the surcharges, and you can have 60 days in which to pay. Mr. Lynch, do you have Mr. Morrow's email address that you can send to Ms. Wright?
I don't know if I have it.
Mr. Morrow, may I have your email address so that we can send you your sentencing sheet, sir?
tmorrow0213 at Gmail.
I'm sorry, say that one more time slowly for me.
tmorrow0213 at Gmail.
Oh, we got it. I got it.
All right, I got that. I have tmorrow0213 at Gmail. All right, Mr. Morrow, you're going to get your sentencing sheet in the mail. It's going to tell you the exact date by which your payment needs to be made. If you fail to pay by that date, an arrest warrant might issue. So please make sure that you do that. And then instructions, if you have any questions, you can contact the clerk's office through the email information, okay? Thank you, sir. You're free to go at this time, Mr. Morrow. All right, ladies and gentlemen, the 11 o'clock calendar, just give me one moment and we'll be back and I'll announce that.
That insurance. Well, that's the message that the judge answers.
Attorney Lynch, I did respond back to you regarding Johnson. So in the 304 courtroom.
Yes, I saw that. I just
Okay.
forwarded the question to him. Okay, Taz, can you
All right, good morning. I'm Judge Tammy Long Hayward. This is the State Court of Clayton County, Courtroom 304. This is the calendar call for a trial. This is November 4th of 2024. We're going to call the cases. If you're represented by an attorney, your attorney is going to speak on your behalf, but I do need to know that you are here. Please make sure that you have your first and last name on the calendar, first and last name on the calendar, so that we'll know that you are here. Mr. Taylor, did you have an announcement on Mr. Johnson? You muted.
Mr. Lynch has spoken out. Mr. Johnson had an additional question, so Mr. Lynch stepped out of the courtroom to speak to him.
And
Okay.
that should be a negotiated plea, Your Honor. He just confirming one thing with his client.
All right, so we'll do the plea in a moment. All right, with the 11 o'clock calendar, the first name on the calendar is John Brashear.
Your Honor, Mr. Brashear is in the courtroom. Attorney Lynch has been speaking with Mr. Brashear. I'm not sure what the nature of the announcement is. I'd ask that it be recalled when he returns to the courtroom.
All right, no problem. Next case on the calendar is Paget Rashim Hassan.
Yes, Mr. Hassan's also present in the courtroom, and Mr. Lynch has been speaking with him, so same announcement at this time.
Okay. Lakila T.D. Joyner, Antonio Stanfield.
Yeah, I'm here.
Good morning, Your Honor. Harley Upsitnik. I'm filling in for Jonathan Overman, who is handling the case now, and on behalf of Mr. Joyner, who is here on Zoom.
Okay.
And we are ready to accept the plea offer that was given.
All right. Ms. Hagler, Ms. Bing, Ms. Hagler, is that your case?
Yes, Your Honor.
All right, Mr. Joyner, may I see you, please? All right, sir. Raise your right hand for me, please. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes, ma'am.
All right, you can put your hand down, sir. You're before the court on case 2022 CR 01073, Makila T.D. Joyner. You're represented by attorney Harley Upsitnik, who's here with you. And you are entering a plea. Ma'am, what is your client pleading to? Driving under the influence, count 1, DUI less safe, count 2, and distracted driving, count 3.
We are pleading to count 1.
All right, by entering a plea of guilty to driving under the influence per se, count 2 will merge, count 3 will be no pros. You give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And sir, if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. You understand all of these things, sir?
Yes, ma'am.
All right, factual basis and recommendation, please, Ms. Hagler.
Yes, Your Honor. One moment, please. Yes, Your Honor. On or about November 11th of 2021, Officer Brian Jackson was dispatched to investigate a vehicle accident at I-75 South and Charles West Grant Parkway, Atlanta, Georgia, 30337, Clayton County, Georgia. Upon his arrival, he observed a silver Honda with extensive front end damage. He also observed deployed airbags in the vehicle. He also observed a strong odor of alcohol coming from the defendant's vehicle. He made contact with the defendant, who was also being evaluated by fire EMS. Officer asked the defendant if she had consumed any alcoholic beverages. The defendant stated that she had consumed 3 shots of tequila, 1,800 hours, approximately 45 prior to driving. The defendant was asked how did the accident occur, and the defendant said that she was driving south on I-75. The defendant also stated that she looked at her cell phone, which was sitting on her lap, and at that time she then struck and hit the median. During his investigation, the officer did conduct the HGN, horizontal gaze and stagnance exercise, as well as the walk and turn, as well as the one leg stand. The HGN, the officer noticed 6 out of 6 clues. With the walk and turn, the officer noticed 5 out of 8 clues. And with the one leg stand, the officer noticed 3 out of 4 clues. Your Honor, the state's recommendation for count 1, 12 months to serve, 24 hours, a fine of $300. And I'm sorry, also, Your Honor, the defendant's VAC was a .208 based on the GBI lab results. 40 hours of community service, balance probated. The defendant is to complete the DUI alcohol risk reduction program, to have no drugs or alcohol, to complete the substance abuse evaluation and treatment, and follow all recommendations. And count 2 is going to merge in the state, so now cross count 3, Your Honor.
All right. Anything else on behalf of your client, ma'am?
2 things. One, I want to clarify that the served 24 hours, he gets credit for time served.
Yes.
And then can we get an affidavit of first offense, please?
Yes, you can get that from the clerk's office.
Okay, thank you.
Sir, I'm going to accept your plea. I'll send you to, on count 1, to 12 months to serve 24 hours credit for time served. Balance will be probated for you to take a substance abuse evaluation and any treatment may be ordered. No alcohol or illicit drugs during the course of your probation, and you will be screened randomly for alcohol and drugs. You're to take a risk reduction course and pay a fine in the amount of $300. There'll be the fine will increase based on the surcharges, but I can't tell you what it is because on DUIs it's enhanced beyond what I've memorized. So generally it'd be $444 total, but it'll be closer to 5, maybe 5.5, 550 if you are on the DUI. All right, so I'm going to put you in a breakout room with our intake specialist for probation.
Okay.
And just a few words, the quickest way to mess up on probation is to fail to report to probation. Our probation officers specialize in helping you successfully complete probation. So please make sure that if you have any difficulties, you communicate those difficulties to them, okay?
Right, okay, thank you.
Thank you. I'm going to put you in a breakout room number 6 with Ms. James. Once you've finished speaking with Ms. James, you do not have to come back here to the main room. We'll go ahead and just begin doing your probation assignments, okay?
Okay, thank you.
All right, thank you. All right, so the invitation to the breakout room has been sent. Anything else on behalf of your client, ma'am?
No, Your Honor, and that concludes my business. May I be excused?
Yes, thank you.
Thank you.
All right. All right, next on the calendar is Jared Alexander Major, Khalil Edie. Do we have a waiver? Jared Alexander Major, I don't have anything on that.
I don't either. The state will move for a bench warrant bond forfeiture, Your Honor.
Judge, Mr. Edie, filed a conflict.
Oh, okay. So, all right,
On the call too.
attorney conflict, so that case will be moved to the next calendar call. Kevin L. McLean, Lister Holt Dennis.
Mr. McLean should be on the call. We did speak to him unless, Mr. McLean, are you in the courtroom?
Yes, sir, I'm here.
We'll just request a conference with the state at the end of the call.
All right, my understanding is you need to break out with the state.
Yes, Your Honor.
All right. Next case is Diane Rashid Miles. Diane Rashid Miles.
Mr. Miles is not present in the quorum, Your Honor. Mr. Miles was initially appointed at arraignment,
Okay,
and we do not have a good phone number for Mr. Miles, Your Honor. I've been attempting to locate him so I could follow up on his case. And we'd initially even filed a motion to suppress that he also didn't get, apparently didn't get notice for because he didn't attend. I don't know.
all right. Mr. Miles has a responsibility, as does everyone, to update the court if you move from the location that the court has notice of. So we'll go ahead and issue a bench warrant bond forfeiture.
Thank you, Judge.
All right, next is Sarah Pimentel Alcantar.
Good morning, Judge Jason White for Miss Pimentel Alcantar. She is on. If she can turn on her Zoom. If I could just have a brief breakout room with the state, I'm pretty sure we're going to be able to work this case out.
And I believe we need an interpreter. Is that also correct?
I believe so. Yeah. Yes.
A Spanish interpreter, Judge.
All right. All right, so Miss Val is going to get an interpreter as soon as we get one available from one of the other courtrooms, I'm sure. Jose Luis Rodriguez.
That is my case, Judge. Mr. Rodriguez should be also on the Zoom meeting. I cannot verify.
He's here. Yeah, he's
Oh,
here.
I thought so. Okay. I also need a breakout room, and we will need an interpreter. I need to speak to the solicitor. She made an offer, but it's not clear on the copy that I received.
All right, no problem. So the interpreter will be here as soon as we can get her or him in from another courtroom. And we'll, as soon as we have the opportunity to put you in a breakout room, we will do that.
Thank you.
All right. Then the next case is Guadalupe Rodriguez Gomez.
Hello, Your Honor. Kazuma Sonoda for Ms. Guadalupe Rodriguez Gomez. That case will be a plea, Judge, and we also need an interpreter.
All right. So we'll go ahead and we'll be ready for the interpreter. We'll be ready for the plea as soon as the interpreter gets here. All right. Thank you, sir. Timothy Liddell Williams, 2 cases. One is Holt.
He is in the courtroom, Judge. Mr. Taylor is talking to him right now.
All right. Do I need to appoint on the other case?
Yes, Judge. Yes.
All right. Go ahead and send me an order.
Judge.
All right. So that concludes the call of the calendar. I'm going to go back. Mr. Lynch, I had 2 that you were out in the hallway for, I think. John Brashear and Rashim Hassan.
So I think initially I was out in the hall. I do have an announcement from a 10 o'clock calendar. I'm not sure if we've made much progress on the 2 11 o'clock cases you just mentioned, Judge.
Are they here?
They are here. I have Mr. Brashears in the back of the courtroom, and I do know a little bit about that case. I will likely need to talk to Ms. Hagler. I think we're hoping to get a resolution today, but there's a few moving pieces. And then Mr.
All right, so Brashear and Hassan are here. You're doing breakout, joiners a plea. Major's a conflict. McLean, you want to speak with the state. Miles is a bench warrant bond forfeiture. Pimentel Alcantor, a conference with the state. Rodriguez, conference with the state. Rodriguez Gomez is a plea, and Williams is in the courtroom, correct?
Yes, Judge.
All right. So, Mr. White, I'm gonna go ahead and put you in a breakout room, and with the state, and let's see if we can, be prepared once the interpreter gets here, okay?
Thank you, Judge.
All right, so I'll put you in breakout room number 1, with Ms. Hagler.
And Ms. Bing.
And Ms. Bing, yeah, both of them are in there.
Thank you, Judge.
All right, so Mr. White, you have the invitation, Ms. Bing, Ms. Hagler, you're all in breakout room number 1. All right, so Mr. Taylor, do you have an announcement? You're looking at me.
Yes. For Mr. Williams on
Yes.
the 6898 case, we're announcing ready at this time. And we just asked we'll send over the appointment order on case 02054, and we just asked that the solicitor's office send us discovery on that matter as well. And we'll have our E&D and appointment order sent over later today.
All righty.
Thank you.
All right, so ready on the Williams on one of the cases, and discovery and an appointment order on the other.
Your Honor, I'm sorry. I didn't receive a breakout room invitation.
Ms. Bing?
Yeah, it never came up.
It should, like, if you move your cursor, it should pop up again. Let me see if I can, because you were still in there.
Let's say join breakout room.
No, I've seen it before. It comes up, but
it might not pop up, but you might have to move. What does it look like, Mr. Taylor?
Four squares. One of them is whited out at the bottom where the toolbar or task bar thing is. That's what it looks like on my screen anyway. If you don't see that, then I don't know.
Okay. All right. Thanks so much. I'll figure it out.
See it, Ms. Bing?
No, but I'll figure it out.
Okay, no, then hold on. I'm gonna move you, but don't go in until I tell you, because I'm gonna move you to one room and move you back, okay?
Okay. All right. Thanks.
All right.
Okay, I see that now.
Okay,
Room
don't
5.
click on that one.
Okay.
I'm gonna move you to the correct room now.
Okay. All right. I see room 1.
There you go.
All right. Thank you.
You're welcome. All right, and when we come back, Mr. Handelman, you'll have an opportunity to speak with Ms. Hager when she's finished.
Okay.
And then Mr. Lynch, if you need to speak with the state on, I know Bashir, and on McLean, you may need it on Hassan also.
Correct, Judge. And then I believe we'll be ready for a plea on Mr. Johnson from the 10 o'clock calendar whenever the court is ready and when Ms. Hagler is ready for that as well.
Okay, thank you.
Attorney Henselman, are you still requesting a breakout with us?
Oh, say that again, I'm sorry.
Are you still requesting a breakout room with the state?
Yes. Uh-huh.
Okay. Your Honor, did she log off?
Yes.
Can you please put Attorney Henselman in a breakout room with myself and Attorney Bing, please?
I will.
Thank you. And will it still be breakout room 1, Judge?
Yeah.
Thank you. Okay, I'm headed there now. Thank you, Judge.
Ms. Val, have we heard from the interpreter?
No, ma'am. I requested them, but we're just still waiting on them to find out. 1 second.
Okay. Ms. Wright, I'm gonna sign those. For some reason, they were, there were some of them that were coming up in the sign box, but when I clicked on them, they wouldn't open correctly. So let me hopefully I can get these done also.
And Your Honor, the interpreter was in the courtroom about 15 minutes ago, so I believe she's still on the floor. Probably in another courtroom.
Okay, yeah, we did make contact, so she's probably taking a plea or something.
Thank you, Judge.
Judge, if you still have a problem opening those, I can send hard copies to your office.
No, I think it'll work. I'm gonna look at it again. Let me see. Because I think when you resent them, I think you sent them differently. Let me see. It'll open this time. Sometimes the page shows up and I can like read the page as soon as I open the email. Sometimes there's a box that I have to click on and I'm not sure the difference. But when I click on the box recently, it's been an issue with trying to open the box, and when I open it, there's nothing there. So let me just try it, and if it doesn't come through, then I'll let you know.
Okay, no problem. Thank you.
Thank you. I'm not sure why the change, but sometimes these programs update, and it's not an update that I'm happy with.
Amen to that.
And Your Honor, once Attorney Handelsman return back to the Zoom, we will have an announcement.
Okay, no problem.
The interpreter is present, Judge.
I'm sorry. She's present?
Yes, ma'am.
Okay, cool. Thank you. They're good. Yeah, I think we're good, Miss Wright. I think these opened up and I can see them. One second, ladies and gentlemen. I'm sorry.
Yes, Your Honor.
All right. So since our interpreter's here and we're ready on the plea for Rodriguez Gomez, we can go forward if we're ready.
Is that me?
Well, is the attorney still on?
Yes,
Yeah,
gonna be on right now.
Okay.
All right.
Her camera is too high. Can you bring the camera down a little bit?
Yeah, I can't see anybody. I see the ceiling. There we go. Thank you. All right. Good morning, Ms. Bermudez.
Good morning, Your Honor. How are you?
I'm good. Oh, I'm sorry. I'm not good. My camera's off. Let's see. There we go. All right. So, Ms. Rodriguez Gomez.
Señorita Rodríguez Gómez.
Sí.
Please raise your right hand for me.
Por favor, levante su mano derecha para mí.
Do you solemnly swear or affirm any testimony you give in this matter will be true?
¿Jura usted y afirma solemnemente que cualquier testimonio que usted dé en este asunto va a ser la verdad?
Sí.
Yes.
All right. You can put your hand down, ma'am.
¿Puede bajar su mano, señora?
You're before the court on case 2021 CR 06774.
Usted está ante la corte debido al caso 2021 CR 06774.
You're represented by attorney Kazuma Sonoda.
Usted está siendo representada por el abogado Kazuma Sonoda.
He's here with you on the calendar.
Y él está con usted en la lista de causas.
Sí.
Mr. Sonoda, what is your client pleading before the offense no license?
We're
Señor
pleading guilty, Your Honor.
Señor Sonoda, ¿cómo se declara a su cliente del delito de no licencia? Nos estamos declarando culpable, su señoría.
By entering a plea of guilty, Ms. Rodriguez Gomez, you give up the right to have a trial by jury or judge.
Al declararse culpable, señorita Rodríguez Gómez, usted renuncia al derecho de tener un juicio ante un juez o un juicio ante un jurado.
You give up the right to have the state prove your guilt beyond a reasonable doubt.
Renuncia al derecho de hacer que el Estado pruebe su culpabilidad más allá de una duda razonable.
You give up the right to have the presumption of innocence in your favor.
Renuncia al derecho de tener la presunción de inocencia a su favor.
You give up the right to present evidence and testimony on your behalf.
Renuncia al derecho de presentar pruebas y testimonios para ser usados en su defensa.
To not incriminate yourself or present any testimony or evidence against yourself.
De no incriminarse a sí misma o de presentar testimonios o pruebas en contra de sí misma.
And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status.
Y si usted no es ciudadana estadounidense, una declaración de culpable o de nulo podría afectar de forma negativa su estatus inmigratorio.
Do you understand all of these things, ma'am?
¿Entiende usted todo esto, señora?
Sí, señora.
Yes, ma'am.
All right, factual basis. and recommendation, interpreter speed, please.
La determinación de hechos y la recomendación a la velocidad del intérprete, por favor.
Okay, on August 12th, 2020,
El 12 de agosto del 2020,
in Clayton County,
en el condado de Clayton,
at Rock Cut Place and Lonky Lane,
en la Rocker Place y Monkey Lane,
the defendant drove on a public roadway
la acusada estuvo conduciendo en las carreteras públicas
without a driver's license.
sin tener licencia de conducir.
She advised law enforcement
Ella le informó a los agentes del orden público
that she does not have a Georgia license
que ella no tiene licencia de Georgia
or a license at all from any U.S. state.
o de una licencia en lo absoluto de cualquier estado en los Estados Unidos.
She was stopped by law enforcement. I'm sorry. She was, excuse me one second. Yeah, so she was stopped at a roadblock
A ella la pararon en un retén,
authorized by Lieutenant Arroyo.
al cual fue autorizado por el teniente Arroyo.
That concludes the factual basis.
Esto concluye la determinación.
The state recommends 12 months to serve, 2 days suspended.
La recomendación son 12 meses para servir 2 días suspendidos
And the balance suspended of $500.
y el balance suspendido de $500.
Thank you.
Gracias.
Okay, are we suspending the fines or she's paying the fine?
¿Estamos suspendiendo la multa o ella está pagando la multa?
So we're suspending the fine. So if
Yes,
something
she's
like
suspending
this,
the fines.
Okay. I'm just wondering, because sometimes when we say balance suspended, it's for them to pay in less than 12 months. So like they'll get 60 days.
Yo solamente quiero saber porque a veces cuando balance suspendido es para ellos pagar, o sea que tendrían 60 días.
Right. Anything on behalf of your client, Mr. White? I'm sorry, no, Mr. Sonoda.
So Judge, I'm
algo
sorry,
por
I got
parte-
confused by all that. So the balance, basically upon payment of the fine, the sentence is suspended is what I want to make sure is everyone's understanding, correct?
Yes, will she need more than 60 days in which to
No.
pay?
Not at all, Your Honor. We're going to pay as soon as possible. Thank you.
Okay, well, can it just be 500 to pay within 60 days?
Yes, Your Honor.
All right. So $500 fine, 60 days in which to pay. The fine will be $737.50 with the surcharges.
O sea que serían $500, tendría 60 días para pagarlo y la multa sería un total de $737.50.
Sí, sí, señora.
Yes, ma'am.
All right. Now, Mr. Sonoda, all we need is an email address for the sentence sheet to be sent to. If you want to give us yours, that's fine, as long as you can communicate that to your client.
I will, Your Honor. Do you want me to put it in the chat or do I?
Yes, please, but you're chatting it to Amanda Wright, R-Y-T-E. So after, if you click on the name in blue in the chat function, she should be the first name that comes up after that.
Yes, Your Honor. Thank you so much.
All right, thank you, sir.
Judge, I need some clarification.
Yes, ma'am.
We're not
It's-
doing the 12 months suspended and the 2 days. We're just doing the fine.
Yes, ma'am. $500 fine and 60 days to pay.
Thank you.
You're welcome. All right, so once you've sent your email address, Mr. Sonoda, then you and your client are free to go at that time, okay?
I did, Judge.
Let me check. Yeah, I was checking. There's a Ira Maria Onate listed as the bondsperson. So if that is someone who's known to Ms. Rodriguez Gomez, they can get their bond refund now that the case has been resolved.
I will tell her. Thank you very much.
All right. Thank you.
Yeah.
Okay.
Take care.
All right.
Bye.
All right. You too. All right. Next, I guess we have Pimentel Alcantar and Rodriguez. Do we have announcements on those cases?
Judge, on Jason White for Miss Pimentel, it's very likely going to be a plea. If I could just get a minute with the interpreter and my client in the breakout room.
Sure.
I think we would be able to close this out.
And on the Rodriguez case, Mr. Handelsman, did you all have an announcement?
He did, but I don't see him back in the breakout room. I don't see him back in the main room though.
Let me see if I can. Okay, Mr. White, Ms. Bermudez, and Ms. Pimentel, I'll put y'all in a breakout room and then I'll see if I can rescue Mr. Handelsman. All right. Breakout room number 4, Mr. White, Ms. Pimentel, and Ms. Bermudez. And when you all are back, then we'll proceed.
Thank you, Judge.
4, Ms. Pimentel. All right, the invitations should have gone out, and Mr. Handelsman still stuck. Okay, let's see. Mr. Handelsman, you can activate your screen and you should see the button to leave the breakout room and return to the main room. All right, I keep trying to move him to the main room. That's not always successful. I sent a message, not sure what else to do. He should be out. If he's not out by the time Mr. White comes back, then I'll go ahead and close all the rooms and that'll kick him out, okay? All right, thank you.
Judge, in breakout room 4, we're all in the breakout room, but for some reason we're able to hear all of the court in the main room. So I'm not sure what's going on.
Let's see. Did you hear me ask about Mr. Handelsman?
We did.
Yeah, that was on purpose. I was trying to broadcast to him, but when I do that, it broadcasts to all the rooms, but I stopped the broadcast.
Oh, okay. Thank you, Judge.
Yeah, I'm sorry. I'm just trying to get him out of the breakout room.
Nope, not a problem.
Okay.
Just for Mr. Cadet and I have Mr. Johnson. Holding on plea with Mr. Johnson. Hold on, she responded to something. Yes, please bring to the office. Then respond down there. Thanks. I'm gonna walk it down. Yeah. The only thing about Mr. Johnson is we need to activate for that. Mr. Pichette should be good to go because I'm walking this down here, right? Okay. Mr. Hassan.
Is it Edie or Eddie? Mr. Eddie? Or is it Mr. Edie?
It's Edie.
Okay, so Mr. Edie, you're here on behalf of Mr. Major.
Yes, Your Honor.
All right. How can I help you, sir?
It's a newer case for me. I just was fully retained on this case. So I sent over, I believe I tried to mail over entry. My paralegal is out, but I believe we mailed over one Friday.
We got your entry.
All right, and I believe my discovery request was on that as well. So we'll just be asking, I will be asking for a one-time continuance to allow me to reach the prosecutor, get the discovery, come down and pick up the video, and be available for the next calendar call.
All right, that sounds fine to me. Just follow whatever procedures they have for the video, and then we'll see you on the next calendar call. Mr. Major, your attorney is going to be able to communicate with the state to get information on your behalf. Just please make sure that you keep in touch with your attorney so that you all will be ready on the next calendar call.
Okay, thank you.
All right, thank you. Thank you, Mr. Edie, for making the effort to be here.
Thank you. And Yana, I know by any chance if you can be able to tell me which ADA is assigned to the case?
It's either Ms. Hagler or Ms. Bing. I'm not sure which one will be assigned at that time. Probably Ms. Hagler.
It's going to be me, Your Honor, yes.
Okay. So Ms. Hagler, and then you can just communicate with her.
Will do.
Is your number correct under Mr. Edie? 046664854, is that correct? Okay, perfect.
Yes.
Thank you.
All right, perfect. Thank you, sir.
Thank you.
All right, thank you, Ms. May. Yes.
Thank you.
All right, Mr. Handelsman. Okay, did you have an announcement on your case?
Yes, Judge. We just got the offer from the solicitor. We would like to have a plea date so I can go over the paperwork with my client prior to entering the plea. And could you please note on the file, he will also need a Spanish interpreter.
All right, so we have our interpreter. Did you want to do a breakout room and finish it today, or did you need additional time?
I need additional time, Judge. That's what I'm asking for, a specific plea date.
All right, Ms. Val, what's going on Tuesday?
Next, what date?
Hold on a second, Mr. Handelsman. Do we have room on Tuesday's calendar? Next Tuesday, not tomorrow.
Yes, ma'am.
Okay, so I'm sorry.
Which case is it?
That would be Jose Luis Rodriguez, 2021 CR 06859.
Okay, next Tuesday, 10.
Yeah, so not tomorrow, but next week, Tuesday, Mr. Handelsman.
That's November 12th.
A week from tomorrow.
No, the 12th, November 12th.
November 12th. What time, Judge?
10 a.m. video calendar, same video sign in.
10 a.m. November 10th. Okay, thank you, Judge.
All right, Mr. Rodriguez, Ms. Ramirez, if you can assist me. Mr. Rodriguez, please communicate with your attorney.
Señor Rodríguez, por favor, comuníquese con su abogado.
You'll be back here by video on November 12th.
Usted va a regresar acá por video el día 12 de noviembre.
At 10 a.m., sir.
A las 10 de la mañana, señor.
The same sign-in.
Y usa la misma clave para entrar.
All right, you're free to go at this time, sir.
Puede retirarse, señor.
Thank you, Mr. Handelsman.
Thank you, Judge.
All right, and are we ready, Mr. White, with Ms. Pimentel Alcantar?
We are, Judge. It's going to be a plea, and we're ready to go on that.
All right. Ma'am, raise your right hand for me.
Señora, levante su mano derecha para mí.
Do you solemnly swear or affirm any testimony you give will be true?
¿Jura usted y afirma solemnemente que cualquier testimonio que usted dé va a ser la verdad?
We
Sí.
can't hear. Oh, there you go.
All right, you can put your hand down, ma'am.
¿Puede bajar su mano, señora?
You're before the court on case 2021 CR 07027.
Usted está ante la corte por el caso 2021 CR 07027.
State versus Sarah Pimentel Alcantar.
El Estado contra Zaira Pimentel Alcántar
For no license within 30 days and stop or yield sign violation.
por no tener licencia dentro de 30 días y por una infracción de pare o de no ceder el paso.
You're represented by attorney Jason White.
Usted está siendo representada por el abogado Jason White.
Mr. White, what is your client plead to the offenses before the court?
Señor White, ¿cómo se declara su cliente de los delitos ante la corte?
Judge, as part of the negotiations, the state has agreed to dismiss count one, the driving without a license, and my client would be entering a nolo contendere plea to count two, the stop sign violation.
Su señoría, como parte de las negociaciones, el Estado está de acuerdo en desestimar el cargo de manejar sin licencia de conducir y de que ella se declare nulo de la infracción del pare.
All right. By entering a plea of nolo to count two, you give up the right to have a trial by jury or judge.
Al declararse nulo del cargo número 2, usted renunciaría al derecho de tener un juicio ante un juez o ante un jurado.
You give up the right to have the state prove your guilt beyond a reasonable doubt.
Renuncia al derecho de hacer que el Estado pruebe su culpabilidad más allá de una duda razonable.
You give up the right to present evidence and testimony on your behalf.
Renuncia al derecho de presentar pruebas y testimonios para ser usados en su defensa.
To not incriminate yourself.
De no incriminarse a sí misma.
And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status.
Y si usted no es ciudadana estadounidense, una declaración de culpable o de nulo podría afectar de forma negativa su estatus emigratorio.
Do you understand all of these things, ma'am?
¿Entiende usted todo eso, señora?
Sí.
Yes.
Factual basis and recommendation, interpreter speed, please.
La determinación de hecho y la recomendación a la velocidad del intérprete, por favor.
Yes, on December 18th, 2020,
Sí, el 18 de diciembre del 2020,
in Clayton County, Georgia,
en el condado de Clayton, en el estado de Georgia,
the defendant was driving a motor vehicle
la acusada estaba conduciendo un vehículo de motor
and failed to come to a complete stop after approaching a stop sign.
y no se paró completamente cuando se acercó al pare.
The stop sign was located at the intersection of Homestead Drive and Highway 42.
Can you repeat the name of the street for the interpreter? The interpreter didn't hear that.
Okay, sure. The stop sign was located at the intersection of Homestead Drive and Highway 42.
El pare estaba localizado en los cruces de carretera de la Homestead Drive y la carretera 42.
The state's recommendation is a $100 fine,
La recomendación del Estado es una multa de $100.
and that concludes the factual basis and recommendation.
Esto concluye la determinación de hechos y la recomendación.
Anything on behalf of your client, Mr. White?
Algo por
No, Judge.
por
Judge.
parte de su cliente, señor White.
No, Judge, we would just ask the court to accept the plea as negotiated and the resolution that we've negotiated. I believe she can pay that in standard as well.
No, su señoría, nosotros solamente le pedimos a la corte que acepte lo que hemos negociado y la resolución del caso que hemos negociado, y yo creo que ya ella puede hacer el pago de esto también.
Because Ms. Pimentel Alcantar is not at the courthouse, I always give a minimum of 30 days.
Por el hecho de que la señorita Pimentel Alcántara no está en el tribunal, yo siempre le doy un mínimo de 30 días.
The amount with the surcharges, the total will be $150.
La cantidad total con los recargos, el total va a ser $151.50.
And I just need an email address to send the sentencing sheet. It can be yours or hers, Mr. White.
I will send you mine, Judge, and I'll send it to, do I send that to Miss
Amanda Wright, R-Y-T-E.
I will chat that over to her right now.
Thank you.
Thank you, Judge.
Y yo solamente necesito un correo electrónico, señor White, para enviar la orden de la sentencia, y el señor White dice que él se lo va a enviar el suyo a la señorita White.
All right. Anything else at this time?
No, Judge, we just asked that the court, I'd ask to be excused. That concludes my business. I have sent that to Miss Wright, so.
All right, so Ms. Pimentel, Mr. White, you're excused at this time. Thank you.
Thank you, Judge.
Señor Pimentel, señorita Pimentel, usted y el abogado White se pueden retirar en estos momentos. Muchas gracias.
Gracias.
Thank you.
Mr. Lynch, do we have anyone else on this calendar? Because our next calendar is not until 2. Do we have anyone else on the 11 o'clock calendar who has need of an interpreter?
No, Judge, no one in the courtroom, and no Lister Holton Dennis clients.
All right.
Interpreter today.
All right, sounds good. All right, Ms. Bermudez, thank you so much, ma'am.
Yes, ma'am, thank you.
All right, Brashear, Hassan, and McLean. Do y'all need breakout rooms? What's going on with those cases?
Judge, for Hassan, we have a plea ready to go. Negotiated plea.
Mm-hmm.
And for Brashear, I'm going to need to do a breakout room with Miss Hagler because I have some things I want to bring to her attention. And then the other, who was the other person you mentioned?
McLean.
McLean.
And then call Mr. Johnson up so we can take his, oh, wait, I'm sorry, Mr. Johnson's on video. We'll take Mr. Johnson's plea next.
Okay. Could you call or do a breakout?
All right, Mr. Johnson.
Can we put Mr. Taylor's computer in a breakout room with Mr. McLean? That way we can hopefully at least understand where we are. He's on the he was on the
I don't know what he looks, because I'm not seeing McLean.
Kevin.
I thought he was in the courtroom.
Kevo 2.
Kevo 2, I believe.
Kevo 2, oh Lord. All right, Mr. Johnson, is that you? Kevo 2?
Oh, that's Mr. Kevo. Yule Johnson is on.
I mean, Mr. McLean, is that you? Kevo 2?
I think so. I can't see my username, but I am still here.
All right, hold on. Okay. I'm going to put you in a breakout room with Mr. Taylor. Hold on a second. You'll see the invitation pop up. And Mr. Johnson will do your plea in a moment. Okay, just let me get Mr. Mr. McLean situated.
No problem.
All right, Mr. Taylor, computer and Mr. McLean are in breakout room number 2. Mr. Johnson, may I see you, please?
Mr. Johnson, if you could just unmute your mic and turn on your camera for the court, is what she's asking.
All right, Mr. Johnson, I've seen your hand is raised, but I don't know what to ask if I can't hear you or see you. Let's see.
Mr. Johnson, at the bottom of your screen, there should be a little microphone icon and a video icon that looks like a little video camera sort of representation. You should be able to click both of those, and that should bring you.
There you are.
You are.
All right, so Mr. Johnson, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes.
All right. Mr. Johnson, you're before the court on State of Georgia versus, let's see. All right, State of Georgia versus Yule Johnson. All right, Yule C. Johnson 2021 CR 06172 for you're represented by the law firm of Lister, Holt, and Dennis. Mr. Lynch is your attorney. It's count 1, driving under the influence per se. Count 2, driving under the influence less safe. Count 3, open container, and count 4, no tag, expired or invalid tag. Mr. Lynch, how does your client plead to the offenses before the court?
Judge, he pleads guilty to count 1 DUI per se, guilty to count 3 open container. Count 2 merges, and count 3 will be null pros pursuant to the negotiation.
All right. So, Mr. Johnson, by entering a plea of guilty to counts 1 and 3, count 2 will merge, count 4 will be null pros. You give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf to not incriminate yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, sir?
Yes.
All right, factual basis and recommendation, please.
Yes, Your Honor. On or about February the 9th of 2021, Officer K. Mayfield responded in reference to a person down at the intersection of Highway 85 and Garden Walk Boulevard, Riverdale, Georgia, 30274, Clayton County. Upon his arrival, he observed the defendant's vehicle parked in the turning lane, which is intended for drivers to turn left onto Garden Walk Boulevard. Upon approaching the defendant's vehicle, he observed the defendant in the driver's seat of the vehicle pass out and unresponsive while the vehicle was still running. Officer Mayfield attempted to get the attention of the defendant by knocking on the driver's side window, but to no avail. At that time, Officer Mayfield utilized his baton and he struck the passenger side window, breaking it and unlocking the passenger side door. Upon breaking the passenger side door, the defendant woke up. Upon opening the passenger door, Officer Mayfield observed 4 cans of Schultz, SCHLITZ, high gravity alcoholic beverages, which upon Officer Mayfield's inspection were 1 pint each. The officer instructed the defendant to turn off the vehicle and step out of it. Upon speaking with the defendant, he smelled a strong odor of alcohol coming from the defendant's breath. that Officer Mayfield was able to smell through his mask. Upon asking the defendant if he had consumed alcohol prior to and while operating the vehicle, the officer asked the defendant if he did not mind performing standardized field sobriety exercises. He consented. During the HGN, horizontal gaze and silence exercise, the defendant's eyes were observed to be bloodshot red and not able to perform the stimulus smoothly. Officer Mayfield observed the defendant perform poorly at maximum deviation of the stimulus. During the walk and turn, Officer Mayfield observed the defendant not follow instructions by not touching each heel of his toes to the tip of the other foot. At that time, the defendant was arrested, and then search incident to arrest, Officer Mayfield observed one container of alcoholic beverage in a plastic bag, as if the beverages had been purchased recently. Your Honor, for count one, the state's offer is 12 months to serve, 48 hours, community time served, balance probated, a fine of $500. The defendant is to complete the substance abuse evaluation and treatment and follow all recommendations, no drugs or alcohol, random testing and screens, 40 hours of community service, to complete the DUI alcohol risk reduction program. Count two will merge. Count three, a fine of $200, and then count four, the safe on the non-frost.
Right. Anything on behalf of Mr. Johnson?
Yes, Your Honor. So I did speak to Mr. Johnson. He does want to accept responsibility and enter a plea today. However, one complication is that Mr. Johnson informs me he's currently residing in Florida. He currently is out of work, and he's actively looking for a job right now. But we were going to ask the court if there's any way for at least for him to report via mail-in reporting if he stays in compliance with his other conditions. I know that might be a pretty big ask in this situation, but he does not have a vehicle. He does not have transportation to get to and from Florida and Georgia very often. So I was going to ask if he could potentially complete his probation via mail-in reporting if he stays in compliance.
Ms. James?
Yes, Your Honor.
Is that, I mean, like, how we make that work? For something simple like paying money, that's one thing, but DUI where they got to check in, they got to get randomly screened. How do we do that?
He can get screened in Florida.
Okay, so, all right, Mr. Johnson, I will accept programs that are available. What state, what county are you in?
You got to unmute, Mr. Johnson.
I'm in Pinellas County.
In Pinellas? Okay,
Yes.
so whatever programs for DUI that Pinellas County accepts, I'll accept those. The substance abuse evaluation, the risk reduction course, but you gotta do them, which means you're gonna have to take the responsibility to communicate with them to get the approved courses and submit the completion information to probation in Clayton County. There's really no phone report with probation. It has to be mail because they have way too many cases and clients who to monitor everybody by phone. They will give you a form, which you will make 12 copies of, and you will mail those in. But failure to report is the quickest way to get rearrested. So if you are serious about getting your life on track and finding a job and, you know, kind of trying to take care of yourself in Florida, if you mess up on probation here, you'll come right back here. So I'll send you the 12 months to serve 48 hours, credit for time served, balance will be probated. For you to pay a fine in the amount of $500, it's going to be closer to $1,000 with the DUI surcharges. You're to take a substance abuse evaluation and any treatment that may be ordered. You're to have no alcohol and illicit drugs, and you're subject to random screens for alcohol and drugs. You'll take a risk reduction course and do 40 hours of community service. On count 3, $200 fine will be $298 with the surcharges, and that'll run concurrent, meaning at the same time as your other, your probated sentence from count 1, okay? What I'm going to do is put you in a breakout room with Ms. James, and she's going to explain everything that you need to do to complete your probation. You do need to ask questions regarding your situation. If there's anything that you think might cause some issues, then please bring that up to Ms. James. And if she can answer it, she will. If not, she'll direct you to how to bring that up to your probation officers, okay? I'm going to put you in the breakout room at this time. Anything else on behalf of your client, Mr. Lynch?
None at this time, Your Honor. Thank you.
All right, when you're finished in the breakout room, Mr. Johnson, you'll be free to go. Just make sure that you complete all of the requirements of probation. You understand?
Yes.
All right, thank you. All right, when the, okay, so Mr. James, he's in there. All right, so phone and mail report for that, Ms. Wright, if I didn't say it. See how it goes. And you needed a breakout with the state, Mr. Lynch. Let me put you in a breakout room.
We could do Mr. Hassan's plea and then do that, or if you wanted.
Okay, Mr. Hassan.
You can stand right here just so she can see.
All right, so raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes.
All right, you can put your hand down. You're before the court on 2021 CR 06896 Paget Rashim Hassan. You're represented by the law firm of Lister Holton Dennis. Mr. Lynch is with you. You're entering a plea before the court to DUI, let's say, failure to yield the right of way and no insurance. Mr. Lynch, what is your client plea to the offenses before the court?
Judge, count 1, guilty. Count 2, no contest. Count 3 will be no pros pursuant to negotiations. And
all right. By entering a plea of guilty to count 1 and nolo to count 2, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, sir?
yes, ma'am.
All right, thank you. Factual basis and recommendation, please.
Yes, Your Honor. On or about May 28th of 2021, pursuant to the probable cause affidavit that was completed by Officer E. Thomas, he responded to Lake Ridge Parkway and Highway 138, Riverdale, Georgia, Clayton County, regarding an accident with injuries. Upon his arrival, he observed the defendant's vehicle involved in an accident. Officer Thomas made contact with the defendant and requested the defendant's driver's license, which confirmed that the defendant was the valid driver. Upon investigation, Officer Thomas detected an odor of an alcoholic beverage coming from the defendant's breath and person. The defendant stated that he was coming from his brother's house and he had 2 beers, specifically Michelob Ultra Light, approximately 1 hour before entering the roadway. Officer Thomas asked the defendant if he could check his eyes. The defendant agreed. Officer requested the defendant to step out of the vehicle and walk to the rear of the vehicle to a safe and secure environment to conduct field sobriety testing. While conducting the HGN, horizontal gaze nystagmus, Officer Thomas observed the defendant to have 6 out of 6 clues. The defendant presented with lack of smooth pursuit, distinct and sustained nystagmus at maximum deviation, and onset of nystagmus prior to 45 degrees. As the officer moved to the walk and turn, he observed the defendant to not be able to complete the walk and turn fully, and he observed 8 out of 8 clues regarding the walk and turn. Regarding the one-leg stand, the defendant presented 2 out of 4 clues. Also, the defendant provided a sample breath utilizing the officer's portable breath alcohol sensor, which revealed results of 0.190 grams. At that time, the defendant was detained and arrested. Your Honor, the state's recommendation for count 1 is 12 months to serve 1 day, balance probated, a fine of $500, 40 hours community service. The defendant is to complete the DUI alcohol risk reduction program, to have no drugs or alcohol, to submit to random screens and testing for alcohol and drugs, and to complete the substance abuse evaluation treatment and follow all recommendations. Count 2 is going to be a fine of $100, and the state is going to not post count 3.
All right. Anything on behalf of Mr. Hassan?
I just want to make sure that 1 day is credit for time served. I believe he's
Credit for time served.
served the day.
Yes.
No, Judge, I believe we would just ask the court to accept the plea as negotiated.
All right, Mr. Hassan. Ms. James, were you able to get into the breakout room?
Yes, I was.
Oh, okay, thank you. Mr. Hassan, I'm going to sentence you on count 1 to 12 months to serve 1 day, credit for time served, balance probated, for you to pay a fine in the amount of $500. It's going to be closer to $1,000 with the surcharges, 40 hours of community service, substance abuse evaluation, and any treatment that they may order. No alcohol or illicit drugs during the course of your probation, and you'll be subject to random screens for alcohol and drugs. You'll have to take a risk reduction course. On count 2, it's a fine in the amount of $100. It'll be $151.50 with the surcharges. That will run concurrent with count 1, meaning you can pay it during your probation. Count 3 will be no pros. And Mr. Hassan, the quickest way to get rearrested and to mess up your probation is to fail to report for probation. If you have any difficulties, please ask your probation officer. And during intake, please ask Ms. James any questions that you think might affect your ability to be successful with probation. So when you leave the courtroom, when you step outside the courtroom, turn to your right. The next courtroom is 305. Walk through the first set of double doors, and Ms. James's office is in there. If she's with someone, she'll ask you to wait outside until she's finished, okay?
Yes, ma'am.
All right, thank you, sir. All right, and then a breakout room for McLean and Brashear. All right, I think it's already set up for Ms. Hagler and Ms. Bing to be in breakout room number 1. I'm going to move courtroom 304 to breakout room number 1.
Thank you, Judge.
All right, thank you, and we'll be back.
And Your Honor, if you are there, I do have at least 2 announcements.
All right, we have announcements, Mr. Lynch.
Yes, Judge. So for Mr. Brashears, while the state is going to consider some things I brought to their attention, we are going to make a ready announcement at this time.
All right, Brashear is ready.
And then the same announcement for Mr. McLean.
All right, Rashid McLean is ready. All right, then we will see each of the ready announcements on the calendar on the trial date. Anybody else who has something outstanding, please make sure you make the efforts to get the discovery as soon as possible so that we can move forward on those trial dates. And at this time, the court is in recess until the 2 p.m. calendar. At 2 p.m., we have the
Should be the bond forfeitures and the traffic light, Your Honor.
right. And so bond forfeiture and red light and crossing guard calendars. Those should not take long. So we'll see you all back here at 2 p.m. I'm gonna sign off and then I'll just bring everything back up at 2.